Knowing what you're armed with can help you prevent litigation before it happens. There is often a correlation between the number of pages that somebody's contract is going to be and how much time they've spent in litigation. Failure to plan is planning to fail. And I think there's a lot of ways that you can plan ahead when it comes to your role as a developer and how you see interactions with contractors. If it's not inside of the four corners of the document, it might as well not exist. A global pandemic that affects supply chains and causes labor shortages is no longer an act of God that cannot be anticipated and is excluded. You could get the most aggressive terms, and then you're going to find yourself in a situation where no plumber in the city will talk to you. When it comes to delay claims, notice is my best friend. I love written notice. And again, written notice does not have to be delivered via carrier pigeon or on a scroll read aloud by a courier. Written notice can be an email, and I love an emailed written notice because it's time stamped. When you're communicating about something you're worried about on a job site, write for your future self's mental health and frankly for your attorney's mental health as well.
Welcome to Real Estate Development Land to Legacy.
Real estate development. Real estate development.
Corinne Rockoff, an attorney from Detroit, who is going to share a ton of fun stories with us today.
I hope
Welcome,
so.
Corinne.
That's the plan. Hi. It's so good to talk to you. So excited to talk about all those fun and exciting stories that hopefully we can maybe learn something from, share a little bit of knowledge, but definitely at least be entertaining and learn from other people's mistakes a little.
Excellent. Most beginner real estate developers might not realize how much legal help and advice they really need. It's super important, from structuring the deals to negotiating contracts to managing the jobs. So tell me a little bit about how you approach new deals, new transactions. Corinne, where do you typically start or recommend that your clients start?
My strong preference is always that I hear from somebody before they have a problem as opposed to after, although it doesn't always work out that way. I understand people aren't usually excited to call an attorney. I get that. I don't begrudge you it. But I do find that when our office is involved from the beginning, or whoever your attorney of choice is, and by the way, before I get too far in, I'll make this official formal statement. Nothing you're about to hear from me is any kind of legal advice. If you have a specific legal question, you do have to retain your own counsel. If you want it to be me, you are welcome to call or email, but it's not right now. All right, that aside, my preference is always to hear from folks sooner rather than later in the process. My practice is focused more on the after things go wrong side of the equation, but I have the pleasure of working with people who get to talk to folks on a good day as opposed to a bad day. So if you know what's in your documents when you're at the outset of a transaction, to me, that's like loading your toolbox because you're understanding, okay, what terms are in my documents? What can I do? What can't I do? And a lot of the time, knowing what you're armed with can help you prevent litigation before it happens. Now, I don't always get to see the good part of that, but I think that's always the better way to go, even if you don't find that out sometimes until after you've made the mistake once or twice or five times.
Good advice. Good advice. Yeah, we've found that usually litigators are, and maybe it was just my experience dealing with attorneys in the past, but
Sure.
litigators don't like drafting contracts, they're kind of taking them apart. But the ones who could actually advise us on the perfect contract structure, and then they go and defend it, they know their document, that tends to be the best kind of arrangement.
Yeah. And I do often say that I prefer to be in the business of litigation prevention wherever we can help it. And so even if you're at a point where things are starting to not go as smoothly as you would like, one, if you're working with a good set of underlying documents, you're going to be in a better position just for starters, as opposed to I've seen a lot of things that I will call Franken contracts that are clearly copied and pasted chunks of some other agreement that you saw somewhere or heaven forbid is pulled together from a free trial of LegalZoom or some equivalent. But even if you have that, if you are starting to engage and think about it in terms of what is in your contract earlier in the process, then you know, okay, I might have this option. I have this notice requirement that if you miss it, it can put you in a worse position. So the sooner you look at your contract documents, the better. And sometimes it's hard to look at those documents and really get what you're working with on your own. But if you are familiar with your documents, you can prevent a lot of hardship for yourself in that way. So sooner is always better, even if you didn't think about it beforehand. Sooner is still better. Don't avoid it.
I feel like a lot of good contracts that get pulled together from lots of experience with a lot of what if clauses, they tend to be super long. And when they get that long, then and you just stop reading them and they start glossing over things, right? Until something happens, until something goes
Right.
wrong. And then they're like, oh, where's that clause? I remember we
100%.
went from like I want to say 20-page general contractor agreement that barely anybody ever read to a 5-pager. And that became more of a focal point. But then, of course, something went wrong, and we're like, I do remember there was this one paragraph that would have addressed the situation, but it got eliminated.
And my preference also is that with every bad experience you have, you want to start out with a concise agreement and you want to keep it concise as much as possible. But I think there is often a correlation between the number of pages that somebody's contract is going to be and how much time they've spent in litigation. Because every time you have something go wrong, the instinct often is, oh, I'm going to add a specific brand new paragraph that says, oh, in this thing, if it's the second Tuesday of the month and your electrician is delayed, then X, Y, and Z. People have an urge to get really specific because, frankly, litigation or even things that start to approach litigation can feel traumatic for people, and they have that response. I totally get it. I protect yourself in the ways that you can, but there are broader clauses that if you take the time and think it through in advance are going to protect you not just from the electrician on the second Tuesday of the month, but from the plumber and the mason and whoever else is going to have something go wrong. So, yeah, I'm not much of a sports person, but I think it's a John Wooden quote, "Failure to plan is planning to fail," and I think there's a lot of ways that you can plan ahead when it comes to your role as a developer and how you see interactions with contractors.
Absolutely, very true. So when a new project is being contemplated and we have a property, we have development potential plan, we're getting ready to start engaging investors, start engaging um, consultants, contractors. At which step of this process do you prefer or do you recommend for an attorney to get involved?
Ooh, ideally, wherever you are in the process, ideally yesterday. Um, and I say that a little bit tongue in cheek, but I think the most productive thing is to have a genuine relationship with an attorney who understands your business and understands your goals. And then, for example, with a lot of clients, I work with them to come up with what I'll call a form agreement that's, hey, whether depending on the position you're in with respect to each particular transaction and how much bargaining heft you have, maybe it's your own document you're bringing that's your form contract, or maybe it's a rider that you're going to bring to everybody that you work with on this particular type of project, but that addresses certain frequent flyer issues. For example, I'm always a big fan of adding in finance contingencies to things, of making it clear of, hey, any obligations set forth under this agreement, we're going to have some kind of particular window of time. We're going to come into this transaction with the knowledge that X, Y, and Z isn't going to start, and you're not going to start to incur these costs unless and until you receive notice from me that financing has come through and we're moving forward. And that's just a sample of something that I know has been helpful in the past for some folks. Again, not legal advice, just to apply that disclaimer throughout. But if you have a relationship with your counsel where you have had that conversation a year ago, then you're already ahead of the game and that's built into your standard documents. And then you can really start taking it places. Because much as I love talking to my clients on the phone, I don't want them to need to call me at the very beginning of every transaction because I want them to feel comfortable and go out and do all that stuff on their own. But you have to have good base documents to go do that.
Did I hear you right? That you recommend having either a pre-packaged agreement that we would send to all of our consultants, or at least have certain paragraphs written out and attach that as a writer to the template that the vendor supplies. Is that right?
Yeah, I think, for example, in the context of if you're working with you're engaging contractors, you're talking about doing the physical construction work on the property, having your own baseline rider that you and your attorney have worked out in advance that you're going to attach to whatever contract they give you, that's never going to be a bad call. I think that often is really helpful. I know that doing something like that is a lot more challenging when it comes to putting together financing documents, right? You don't always have that same bargaining power and circumstances are more unique. So when you're talking about a property purchase transaction, once you get to the point where you're starting to move towards due diligence, you're starting to get into the even if you've moved on a standard purchase agreement you're comfortable with, once you start to get into more of the mechanics and the hands-on stuff, that's when you wanna make sure your counsel's in the loop.
What about design team, design consultants? In my experience, we typically would have our own GC agreements when
Mhm.
we operated as a general contractor, and most subcontractors are used to GCs supplying their forms of agreements, but it was not very common with design consultants, architects, engineers, all kinds of related consultants. What would be your advice there?
So that's a really great question because it depends on kind of how you're structuring your relationship with your design professionals, right? If they're the type of folks who are going to come in using, the AIA, which for those who aren't familiar, if you haven't encountered these documents, the American Institute of Architects standard contract forms, right? A lot of folks really, especially for smaller projects, the kind of like design build structure of documents that has that built in. So if you're working on a larger project, generally you're more likely to already come in with your architect a lot of the time before you are making other decisions. That's a tough one because I think that's a stronger relationship because the developer and the architect are going to be way more intertwined with each other and on the same team from earlier in the process. So you do have to be more delicate in negotiating those relationships because they are so much more intertwined than you often have with a sub or somebody that's way down the chain that you aren't that invested in. But I think even if you have a baseline relationship, making sure that whether or not you're engaged in counsel at that early stage as you get things situated with your design professional, making sure that you don't let the scale of your projects grow without updating your documents. Because if your design team can be on your side right up until the minute they're not. I can't elaborate a ton on that one at the moment, but I have seen it recently in a notable way.
Makes sense. Yeah, we've definitely had our fair share of disagreements with arguments, and usually
Yeah.
with specifically design teams, and usually it stems from who's going to be taking responsibility for something new or something unpredicted that
Yeah.
happened in the field. The contractor would typically come in and say, "That wasn't in the plans. We didn't bid on it, so here's the change order." And then the owner says, "It should have been in the plans." And then looks at the design team and says, "Why isn't it in the plans? Isn't this expected?"
Yeah.
And
And
there's
it's
always
often harder. It's so much harder to bulletproof yourself from conflicts with your architect than it's going to be from conflicts with your contractor because the architect, pun maybe intended, a little bit enjoyed, got in on the ground floor when it comes to getting the relationship situated. They're so often just there first. And also, frankly, in a lot of matters that I work on, remember who's making these baseline form documents that even if you're not using an AIA form contract, a lot of contract examples that are floating around out there and that folks tend to use are based off of the AIA documents anyway, that people are consciously or unconsciously absorbing their terms and they very heavily favor the design team and often make them the arbiter of truth, even on a project. And so you have to develop the relationship with your architects and get very intentional about making sure that you trust each other where you can, but also don't forget that they could be your opposing party in the future if things don't go the way you want.
and I think I'd like to reiterate this word that you use several times now, relationship,
Yeah.
because it is super important to maintain relationship at all times with all of the team members, whether it's design, whether it's contractors or any other kinds of neighbors, consultants, because usually, in my experience anyway, litigation is approaching when that relationship is ruined or
Yeah.
never existed.
Once you get to the point of litigation, you're not going to have them on another project and have a good time. And if you do, then your attorney's probably going to maybe shake you a little bit and say, "What are you doing?" But I think uh, you have to think about the ratio of how disputes actually resolve, right? 99% of disputes do not end up in a Law and Order style banging on the counsel table trial the way that people are envisioning. And so that relationship is really what's going to determine, are you able to resolve your dispute, and how much are you going to have to pay your lawyer to engage and do that? How long is it going to take? I do think it's a small world, right? Especially if you're operating in a specific set of geography or in a limited area. Building that relationship solves so many problems. And I do often counsel folks about, hey, you can look at your documents and you can have a really formal notice requirement that when you read it on its face feels like, oh, I have to deliver them a scroll and it has to be formal and aggressive on letterhead. And a lot of the time when you step back and say, hey, these requirements are actually about communication and relationship building. I can give what constitutes contract notice, and I can do that in a really pleasant email that starts out, "Hey, John, hope things are great with your family. Wanted to give you a heads up. We have this concern. So I'm just sending this to you in writing per section of our agreement. And I just want to make sure we're on the same page. Let me know how you intend to resolve." And that can just as effectively check all of the contract requirement boxes as something way more aggressive that's not going to maintain or support your relationship with the other party. So be a person while following your contract terms.
So, what about trying to figure out how to ask the question in the most respectful way?
Please ask it in the way your heart tells you.
uh,
Trust me, I talk to a lot of contractors all day. It'll be way nicer than most of my phone calls to
so when we talk to our partners, property owner partners that we set up a deal with, there's often this conversation of, okay, we got to document our agreement, we got to put everything in writing, and then everybody calls their lawyer and they
Mhm,
say, here's a deal that I'm looking to structure, and whether it's a land deal or a construction deal or hiring an architect. At the very beginning, we have this general idea of a deal, both parties do, and we call the lawyer and say, here's the other party, here's the name of their attorney, give us a contract. And then attorneys have to figure out what is it that we actually agreed on doing, right? And
sure.
sometimes there's money involved and sometimes there's an outline of the project. But my question to a general attorney is, how do you know what the actual scope of work is? Yes, you have your experience, but unless I tell you what the scope of work is, you wouldn't really know about it, right?
Well, and that's yes, that's the whole thing. Unless you communicate between counsel and client about what is actually supposed to go into the contract, it's not gonna reflect reality, and if your documents don't reflect reality, you're going to hit a problem at some point where the work that you're physically doing on site doesn't match what's happening in the documents, and I that is the thing that most aggravates me and why I like being able to work with a client on a longer term basis as opposed to just when things have gone wrong, because we give presentations for clients all the time of, hey, FYI, here are the tools that are in your contract toolbox of how things are supposed to work. But if you're not communicating back and forth and you don't have a good relationship and a good understanding of on the attorney side of what's physically happening on the ground, I do think that sometimes this with the utmost care and love and respect towards my colleagues in the law, not everyone who chose to become an attorney also has a passion for climbing around, getting in the dirt, knowing what's physically happening on a site. And if you don't have enough communication to get that point across and make sure that the people who are typing in an office somewhere, putting your contract together, actually understand what's happening, you are going to have that disconnect. So you have to talk to your counsel. You have to make sure that your counsel is hearing you on the scope of work. And I do see it a lot where there's a form contract and you're negotiating terms and you're negotiating notice and payment terms and whatever. And there's just exhibit A, scope of work, that unless I specifically ask for it, I will never see. It's just an attachment and it's like you've got 5 or 6 attachments: scope of work, insurance requirements, project schedule. And I never see those last three. I'm going to have a really tough time figuring out what you do and don't need in your agreement. And I will say the scope of work is the most frequently litigated close call between scope of work and schedule as the number one and number two things that we most frequently find ourselves litigating about.
Okay, so I got a question about scope of work for you.
Oh, please.
So I've gotten two conflicting advices from different attorneys, and I
Uh-oh.
see pros and cons of both, but I'm just curious what your opinion is.
Again, not
Um,
legal advice, but I will
Not
give you
legal, but yep,
thoughts
yep.
and musings. How about that?
Perfect, and that's exactly what I would like. So we, for the longest time, would have a contract with, and this is mostly on the construction side. It's
Mhm.
I suppose it could be applied on the design side as well,
Sure.
but on a construction side, we would have a template form for the agreement, and then we would have scope of work. And originally, what I always liked doing is I would have my project manager or the project team on the construction site go through the proposal of a subcontractor and literally copy and paste or paraphrase in their own words what that agreement is or what that scope of work is and include that in our agreement. And I figured that if we actually restate what the scope is, then it would be at least our understanding of what we're buying. And if we're all signing it, then we're on the same page.
Sure.
But then we had a number of issues where a subcontractor would have their own form of a proposal, and they would typically have their carve outs and their exclusions and things like that may or may not have been transcribed into our form. And that would be cause for potential issues that in some cases would get up to litigation. And then at some point, another attorney advised, don't bother, don't waste your time, just reference their proposal in your agreement. And because they know what they proposed, you see what they proposed. If you're in agreement with it, then attach it. And you can restate it if you want, but have their proposal as part of your contract documents. What do you
So,
think of that?
oof. All right. You I see the appeal of doing it either way. However, whichever one you choose is what you are signing on to. I will use the non-Latin version of the phrase, but we talk a lot about the four corners of a written contract, right? And that is a deeply literal phrase. We're talking about the four corners of the piece of paper. If it is inside of those four corners, and this is assuming, I would say the vast majority of written agreements have something that's called an integration clause that says the entirety of our agreement is what is written down on this piece of paper. And if there's a reference to an exhibit or a reference to plans or a reference to schematics or whatever, if it's specifically called out within this paper, then it's part of the agreement. If it is not specifically listed within this agreement, no matter how in depth we've talked about it, or if we handed pieces of paper back and forth, or if it's a different agreement that we signed in blood, right? Everything that's within the four corners supersedes and replaces anything else that we've talked about or agreed to before. And the only way to amend what's within these four corners is via a signed writing accepted by both parties, i.e., a change order. So if it does not make it into the agreement, either by specifically referencing the proposal and incorporating it that way, or by retyping or rephrasing or whatever, however you're doing it, if it's not inside of the four corners of the document, it might as well not exist. So you have to make sure that it's incorporated in some way. And if you don't have a scope of work incorporated, I have concerns. You want to, because that's an essential, again, this is a technical term, although it just sounds like regular people words. We talk about essential contract terms. And the big ones that I see people forget a startling amount of the time is what are you doing and how much does it cost? Those are the number one, number two core terms. I also would say that when are you doing it is an essential term, right? And people forget that aplenty as well. But that information has to be specifically referenced. And if you just say, if your specific reference is to the proposal provided by contractor, and maybe they submitted three or four draft proposals, or they bid the project and then they modified it, and then you had a chit chat on the phone and they said, oh, never mind, not that, it gets really fuzzy. So to me, I'm always a fan of physically incorporating it into the contract, either by rephrasing, copying and pasting, or even making a reference to an exhibit that is a copy of their proposal. However, whatever version of the phrasing and however it's set up you incorporate, like that is what you are signing on to. So if anything in their description or in your rephrasing is unclear, it leads to a lot of issues. For example, I've had a number of roofing matters where it was a dispute over what it means on a deep cosmic level to replace a roof. And Is there a substantive difference between a recover in a membrane roof and a replacement? If it is code compliant to do and you just re you add a new layer over the top of an existing membrane roof that has issues, does that constitute a replacement? And these are questions you don't ask yourself unless you're a roofing expert and you happen to have run into this situation before, or unless it's after the fact your roof is having problems and you're looking back at your contract documents. So the more specific you can be in your scope of work, I don't care where you put it, but be specific and talk it through with the other party so you know what you're actually agreeing to.
Good advice.
So either
Ex-
one, take both, put it wherever you want it, but make sure it's clear.
Right. As long as there's no actual conflict where one document says one thing and the other document says another thing, right?
And I would say you don't want to do it twice because even if the tiniest phrasing is what's going to cause you a problem, do it
Mhm.
either way is fine, but make sure that you both understand what it means and that if there's a lack of clarity anywhere in how the scope of work is phrased, that you handle it up front and that you amend it and make that part of your contract so everybody's clear and locked in.
So my next question is about
Yep.
guaranteed maximum price. A lot of
Ooh,
times developers like having these either fixed price or GMP,
sure.
guaranteed maximum price agreements with their contractors, and they feel like it protects them in case of an upside, in case of cost escalations. Their contractor is guaranteeing that they will build that building and they will not exceed certain price. How firm is that notion, in your opinion?
It depends on what the carve outs are going to be in your contract documents, right? A great example of it's a guaranteed maximum price. It is firm. It's firmer than a time and materials agreement for sure, but there are carve outs that people miss in what is excluded from that GMP, right? For example, we saw this a ton. COVID had a huge impact on everything, right? Materials costs, timeline, everything skyrocketed. Pre COVID, almost every agreement had a carve out that was for people call it the acts of God carve out, unplanned and unanticipated and unanticipatable events. And when COVID lockdowns hit, obviously that was very unanticipated. A lot of these contracts actually specifically call out among war, labor dispute, pandemic was literally in a lot of them. So that was the subject of a lot of dispute and a fair amount of litigation. Now, however, you're seeing these contracts change. So the carve out has shifted because there are some folks that are taking the position that we've now had a global pandemic. So actually, a global pandemic that affects supply chains and causes labor shortages is no longer an act of God that cannot be anticipated and is excluded. So now, if there are some of these lingering supply chain issues, lack of availability of workforce, and people are turning to the argument, oh, it's because of a global pandemic, it's the after effects, it's the whatever. So that should be excluded and should be a basis for increasing the GMP or should obligate you to reasonably accept a change order. People are now litigating over that. So, all that to say, I feel like a broken record. You have to know the specific contract term that you're talking about. You can make a really aggressive bulletproof GMP. It might give the other party you're contracting with a panic attack and they might not want to sign it, but you can make those beefier. But a lot of the standard exemptions are for the things that actually are most likely to cause problems on a job site, right? If you have a GMP, but it excludes unanticipated weather delays, I'm located in Michigan. We have a lot of those, right? As if you're in Florida or anywhere in the South the last couple of months, you've probably got a fair number of those too. So you have to look really in detail about what's in, what's out, what is a permissible reason for delay or cost change when you have a GMP.
My favorite is always when the contract documents are not fully baked when you're
Favorite.
asking for that GMP. It's because we've gotten those. We would get a light permit set that has no details, that has no interior designs, that basically has just, we call them cartoons of a building. It's enough to get maybe to get the permits, but it's not enough to build a building. And then the owner says, "Oh, here's a GMP from a contract that I just got." And I'm like, "This GMP is worthless. There's no way your contractor could estimate or guarantee that price without the scope of work known. And if it's not in your contract documents, then there's no scope of work. So you're setting yourself up for change orders regardless.
I feel like for some reason, my heart wants to be secretly teaching a legal terminology class on the side here because I'm about to do another one of, okay, it again sounds like regular words, but it is a core legal contract term that we use all the time that we call the meeting of the minds, which sounds very spiritual and up in the air, but it really is about, are both parties to the contract on the same page? And when you're in a situation like that, I just know you've got one party who's imagining beautiful quartz countertops and another party who is absolutely imagining laminate. And if you don't have things fleshed out and you're just at the cartoon of a building stage, I'm thinking of it. I work with a fair number of folks who are in multifamily housing development, and we had an actual extensive conversation about peel and stick floor tiles. And is a peel and stick floor tile a tile, right? Things like that, that you have to really get on the same page. And if you don't have a project specced out to a reasonable extent, I'm not saying you have to know what color of granite, but you've got to know a, a fair amount more about, are we talking granite or are we talking bargain bin, who knows what, before you launch yourself into a GMP and maybe lock yourself into a deal that is not going to be good for your long-term reputation as well. The other thing that people don't think about is you could get the most aggressive terms and then you're going to find yourself in a situation where no plumber in the city will talk to you, especially in the labor environment we have. So you have to think about it from that perspective too. There's a lot of value to getting on the same page.
And many experienced contractors and consultants in good faith would probably point out things that are missing, and
Right. So that relationship perspective, you need that.
exactly, but you still don't want to set yourself up for being taken advantage of by somebody who's less open and honest, and
Or just
because that,
inexperienced.
or experienced,
It,
exactly.
it's not about malice, and you never know. It could be a 40-year company that maybe it's the second generation that has just taken over and they don't have the same experience that dad and grandpa had. And it's daughter's running the company and is still figuring some stuff out. So never assume. And I have a matter right now with a company that's been doing this particular type of work for decades. And yet somehow it is their first time having to be before this particular planning and approval board, right? You look them up, they've got 40 years and two generations of experience. And you think that you can just assume that they're going to be comfortable and confident in the permitting and approval process for this project. And you thought wrong. So you have to always hope for the best, plan for the worst. And I do feel like as an attorney, I'm always the pessimist and I'm the fun ruiner for everybody. But I'd rather be the pessimist and get to be wrong sometimes than be an optimist who gets really disappointed.
That's a good approach. Good approach. Let's talk about delay claims. You mentioned delay claims,
Oof.
and I really want to talk about it a little bit. We've had our fair share of arguments with contractors, consultants, between owners that having had to do with delays. How do you approach that? What can you advise?
Oh, again, not advice, but what I will contemplate and meditate on out loud with our audience today. I know this is the worst part about being an attorney is I have to listen to every word all the time and I can't help myself. But I don't know. Am I that way because I'm an attorney or am I an attorney because I'm that way? We'll never know. But when it comes to delay claims, notice is my best friend. I love written notice. And again, written notice does not have to be delivered via carrier pigeon or on a scroll read aloud by a courier. Written notice can be an email. And I love an emailed written notice because it's time stamped. And oof, if you put on read receipts, it's proof of delivery, right? These are all great things that we have the power to do. But using your notice provisions not only makes sure that you're meeting contract requirements for giving notice of, hey, I'm concerned about this delay, right? I'm giving you an opportunity to address it and fix it and maybe apply extra manpower and we get back on schedule. So it's giving them that genuine opportunity to resolve it. The worst case scenario often on a project is it's a cascading critical path delay situation where, again, out here in Michigan, we're often up against a weather timeline, especially this time of year. I'm keeping a lot of eyes on a lot of projects that I know have any significant amount of masonry work left, anything. If you want to involve concrete in your life, this is a good time to be wrapping up that portion of the project in Michigan because it could snow next week for all we know. But keeping an eye on things like that on your timeline and as you get close, before it hits that critical path where it's going to put your whole project off schedule, reaching out in advance. That's the key. And then documenting that reach out so that if it does create a cascading delay that starts to impact other folks on site and is putting everything off schedule, that way, if you get to a point after the fact where you are litigating about it, they're not coming to you and saying, I'm not going to be responsible for these damages because how was I to know it would have this impact? If you had told me sooner, I could have fixed the situation. I could have brought on more folks. The more they know that earlier and that knowledge is enshrined in writing, the better position folks find themselves in. When you're communicating about something you're worried about on a job site, write for your future self's mental health and frankly for your attorney's mental health as well, because you want to be able to, without having to go back through hours and hours of context in a text message thread, understand what you were giving them notice of, know what you were talking about, make it clear. I also always appreciate a subject line that identifies what you're talking about. Put the project name in there. Make sure that it's clear who you're talking to. Make sure that don't just say, "Oh, I'm worried this is going to put Matt off schedule." Just say, "I'm worried this is going to put the electrical contractor off schedule," right? Because your audience, once you ascend to the level of notice, isn't just the other person you're writing to, it's the future. So keep those thoughts in the back of your head when you communicate. And then there are always delays, but if they escalate to something, then you're in a better position to handle them.
Yeah, when I ran construction company, I kept telling my project managers that you cannot count on delay claims. Just assume that they don't exist because there's always going to be a way for the other party to explain why they got delayed. And there's always going to be a chain reaction, and it always snowballs. Uh, it's almost impossible to actually execute on that claim. Now, whether it's
Yeah.
actually true or not from legal practice, you can share with us. But that's what I've been telling my team so that they don't rely on that.
That's a great way to communicate with your team about it, and I say that about a lot of things in litigation, frankly. Even if your contract documents say you're gonna get this and it looks like it's set in stone, assume nothing. I had a trial earlier this year where, we had really great witnesses who communicated exactly what happened on site really well. We had a very clear and consistent presentation, and then we had a judge who I am not certain about how conscious everybody was the whole time, and you can never predict what's gonna happen in litigation, and arbitration is the same way, right? It doesn't have the pizzazz of a courtroom, and a lot of contracts call for it, but it's functionally the same thing. So when you get to that adversarial point, you can't bet on anything. So my preference is always to see my clients keep things in their own hands and be able to resolve before it gets to that point. And sometimes it takes a little bit of strongly worded letter on letterhead to encourage people to resolve before you get to the courtroom. And that's workable, but you want to give yourself the tool to win without the need for litigation. You don't want to have to go that route. And we can do it and we can do it successfully when we have to, but you won't have very much fun. So yeah, I think that's a great way to advise the teams that you're working with and help them help you stay out of court.
Yeah, and like I said, put everything in writing, send that email, make it polite. It doesn't need to be necessarily mean or adversarial. It could be very polite and to the point. But
Yeah.
I always tell my team, my partners, pick up the phone and call or go meet with them.
Yeah.
Have regular meetings in person if you can. Have regular phone calls as much as possible. As long as that communication exists, there's always going to be that likelihood of a potential conflict rising to the level of litigation is going to be lower.
Yeah. Keep that
We want
relationship strong. And I also do think that you can always do both in that situation. Have the meeting, have the phone call, and then before you hang up, and I do this personally a lot of the time. It's not just something I do with clients, but say, hey, I just want to make sure for my own notes, I don't want to forget what we talked about. I'm going to send you an email just with the headlines of what we chatted about to say, "Hey, thanks for the chat. Appreciate that you confirmed that you're gonna be able to get this done by the 17th. Looking forward to seeing and then looking forward to seeing you at dinner on Tuesday even." You can keep it social and conversational, but have the personal relationship and just a little sprinkle of written confirmation on top will always make my day to see as a litigator when I get there after the fact.
exactly. Grant, I have a million more questions that I could be asking you. We could probably sit here for 3 more hours talking about this, but
Should
I do
not.
appreciate your time. Anything else that you would like to mention? How can the audience contact you or learn more about your firm?
So we are based in Michigan, just outside of Detroit, but I'm licensed to practice law in Michigan, New York, and Washington, D.C. And we're lucky enough to have a network of other law firms with concurrent and matching practice areas in all 50 states and also a couple international as well if folks happen to need it. So if you have if the ship has already sailed on some of these complex issues and you do need litigation help, or if you are trying to prevent something in advance and you want to have a chat about it, you're always welcome to reach out. I have the joy of a very Googleable first and last name combination. So you can find me through our firm's website. The firm is Madden Hauser, and I'm always happy to chat with folks and make a referral or see if it's something that our office can help with. But for everyone's construction, development, and anything, I end up working on anything that relates to the ground. So that's the best that I can describe it, the ground and what happens on it. I guess my theme today is send that notice email. Beyond that, good luck to everyone. And I know it's an exciting field with a lot of opportunities for great success and adventure along the way for better or worse. So
Thank you so much. Thank you, Grant.
thank you, Eugene. Wonderful talking to you and always happy to do it again sometime.
Excellent. Yes, let's do it.
Real estate development.